Blue Book, Volume 1, Chapter 5, Record keeping and Privacy. Schools must maintain detailed records to show the federal student aid funds are disbursed in the correct amounts to eligible students. The records must be available to authorized parties to course of audits, program reviews, investigations. Personally identifiable information in these records may only be released to the parties under the conditions specified in the FERPA regulations. Required information may be collected and stored electronically, subject to appropriate safeguards. Required records. The school must comprehensive, accurate program and official records related to the federal student aid program funds. Maintaining and completing accurate records is very important. Program and official records must demonstrate the school is capable of meeting administrative and official requirements pertaining to the federal student aid programs. In addition, the records demonstrates proper administration of the federal student aid program funds and must show clear audit trail of the federal student aid program expenditures. For example, records of federal student aid receipts must clearly show that the student was eligible for the funds, received that the funds were disbursed in accordance with the program regulations. In addition to general institutional record requirements discussed in the school must also comply with program specific record-keeping requirements contained in the individual federal state aid federal student aid regulations. Chapter 5 highlights required records, retention periods, record maintenance, examination records, privacy of student information, FERPA, e-signature act, information security, federal student aid assessment modules. To assist the compliance with the provisions of the chapter, the schools should see activity 2 under official management of the information financial associate whatever ifap.ed.gov.qa home qa assessments financial management HTPPL required related to school eligibility. A school must establish, maintain current basis of applicant schools submitted by the federal student aid program funds. Other program records must be maintained, including program participation agreement, improvement letter, eligibility certificate, approval report, ECAR, application portion of the FISAP, accredited license agency reviews, approvals, reports, state agency reports, audit program review reports, self-elevation reports. Record keeping is in Title 34, so Federal Regulation 668-224. Closed school records. If a school closes, stops providing educational programs, is terminated, suspended from federal student aid programs, or undergoes changes in ownership that result in change of control, provides retention and required records. It also must provide access to these records, inspection copies by the department. A school that has formally participated in the FFEL program must also provide access to the appropriate guarantee agency. Retaining records of the branch that closed. If a school has an additional location or a branch that closes, the school should maintain loans records beyond the end of the year and beyond an end of the 3-year record retention requirement to respond to the Department of Refutal borrower claims and eligibility of discharge. Other records and specified regulations that pertain to the factors of financial responsibility, standard administrative capabilities, records reporting relating to student eligibility. School must keep the substantial eligibility of students to federal student aid funds, such as cost of attendance, information, documentation of student satisfactory academic programs, SAP, documentation of student program of study and of the course in which the study was enrolled. Data are used in the established student admission enrollment status of the period of enrollment. Required student certification assessment statements supporting documentation. Documents used in various application data. Resolve conflicting information documentation. All professional judgment decisions. Financial history information of transfer students. Official years of school must keep official records to demonstrate that the purpose of the federal its purpose use of federal student aid funds. The school official records must provide a clear audit trail for the show that the funds were received, managed, dispersed, and returned in accordance with the federal requirements. The official years of the school must maintain, include, or are not limited to records of all federal student aid program transactions, bank statements of all accounts containing federal student aid funds, records of student accounts, including each student institution charges, each cash payments, federal student aid payments, each disbursement, refunds, returns, overpayments required for each of the enrollment period, general ledger control accounts, related subsidiary ledgers. In addition, with federal student aid program transaction, federal student aid transactions must separate them from other schools' other financial transaction. A fully federal work study, payroll records, official operation report portion of the FISAP. A school that maintains records of the support data and appears required reports such as record retention requirements. A school must establish, maintain on current basis an application of federal student aid funds and program records of the documentation of student eligibility to participate in federal student aid programs, federal student aid eligibility for the school programs of education and school administration of the federal student aid programs of school financial responsibility information, including the application of federal student aid programs funds, school disbursement of federal student aid program funds. Official year, school must account for the receipt and expenditure of all federal student aid programs funds in accordance with the generally accepted accounting principles. The school must establish, maintain a current basis official records that reflects the federal student aid program transaction general ledger account, control accounts of the related subsidiary accounts with the indefinity of each federal student aid program transaction separate of the transaction for other school inactivity, other schools' financial activities. Records of federal student aid receipts. The school maintains a record of federal student aid receipts that include but not limited to federal student aid report, institutional student information record, the ISSIR, used in determining student eligibility for federal student aid program funds. Application data submitted by the Department of Lender Grantee Agency by the school on behalf of the student and the parent. Documentation of each of the student parent borrowers' eligibility for federal student aid program funds. Records demonstrating the school of a high school diploma, GED, or ability to benefit. Documentation relating each of the student's parent borrowers' receipts of the federal student aid program funds, including not limited to the amount of the grant loan, the FWS award, if in payment of the period of the long period, if appropriate, the calculation used to determine the amount of grant loan of the FWS award, the date of the amount of disbursement grant loans, and the date of the amount of each federal FWS wages, amount of the date and basis of the school calculation, any funds returned to the overpayments due on the behalf of the students, payments of any refund and return of the overpayment federal student aid program fund lender and the Department of Education as appropriate. Documentation information collected, initial exit loan counseling required for the applicable program regulations, report forms used by the school in participation in federal student aid program, any records needed to verify the data that appears in these reports and forms. Documentation supporting the school's calculation and completion of the graduated rates and transfer out rates. A loan program is entitled 34,668, 24,668, 82, 610, 685, 309. Pell Grant statements, accounts, cash requests, quarterly, monthly reports, G5 payment system, statements, federal student aid program reconciliation reports, audit reports, school responses, state scholarship award reports, accrediting, licensing agency report records used to the prepare income record of the FISAP. Perkins and FWS loans, FWS records. Participation in Perkins loan program must follow the procedures of the Title 34 CFR 674-19 of the documentation of repayment history of each of the borrower for the program. Participation in the FWS program must follow the procedures established in Section 67519 for the documentation, work, earnings, payroll, transaction of the program. Loan program records. The special record keeping the requirements of the direct and FFEL loan programs. The school must maintain a copy of the paper or electronic loan certification or origination record, including the amount of loan period of the enrollment, the cost of tenants established by the financial assistance, and the expected family contribution to calculate the loan amount, and other information required to determine the borrower's eligibility, such as the student federal Pell Grant eligibility or ineligibility. The date of the school disbursed loan funds to the student or the parent borrower, the amount of the disbursed loan derived of the school by check, the date of the school endorsed by the loan check if required, documentation of the confirmation process of the academic year. School uses the multi-year feature for master prosperity note. This may be part of the borrower's file, but acceptable documentation can be also included in the statement confirmation process of the printed student handbook and financial aid publication for the school year. The documentation must be kept in paper and electronic form. There is no retention limit to the documentation, but you must keep it indefinitely because of the law, and it may affect the enforceability of loans. The school must keep a record relating to the student parent borrower's eligibility participation direct loan FFEL program for the 3 years after the end of each award year, and the student has last attended the school. The school must keep all the records relating to the school year participation direct loan and FFEL program last 3 years after the end of the award year for the records are submitted. Records are in Title 34 CFR 66:18, 24, and 27. Record retention records. A school must retain all records for a minimum of 3 years for the ending of the award year. However, the starting point of the 3-year period is not the same for all the records. For example, the FFEL and DL reports must keep for 3 years after the end of the award year in which they were submitted. The borrower's records must keep 3 years for the end of the award year in which the school is last attended. Different retention periods are necessary to ensure enforcement repayment of the Perkins loan, which are normally held by the school. The Perkins loan repayment records include cancellation deferment records must keep all 3 years for the date of the loan assignment. Assigned, the department canceled and repaid Perkins' original promissory. Original repayment check schedules must kept until the loan is satisfied and needed to enforce obligation. For more information on the Federal Student Handbook, Volume 6, Campus-Based Programs. A school maintaining the records longer than a minimum period required. Moreover, the school may require to retain the records involved in any loan claim, expenditure question, and federal student aid program review, audit, investigation, or other review for more than 3 years of the Volume 4, Chapter 2, the information of the program reviews and audits. If the year retention period expires before the issue of the question is resolved, the school must continue to retain all records of resolution reached. A return of the official operation report of the application records. The school participating in campus-based programs must keep an official operations report applications to participants of any records necessary to support their data and e.g. source of the data income grid for the 3 years of the end of the award of the year of the official operations reported application to participate is submitted. For instance, for the official operation report application participate submitted during the 2012-2013 award year must be kept until at least June 30th, 2016, 3 years from the last date of the award year. Minimum record retention periods. The Pell and Teach grants campus-based programs 3 years of the end of the award year from which the aid was awarded. The official operation report and support records 3 years from the end of the year, 3 years from the end of the award year, which the report was submitted. Perkins repayment records until the loan is satisfied. Documentations are needed to enforce the obligation. Perkins original promissory notes 3 years from the date of the loan is signed by the Department of Education, canceled or repaid. Direct loans of the FFEL. Records related to the borrower's eligible participation federal years of the added and the award in which the student was last attended. Other records include any other reports or forms 3 years from the award of which the report was submitted. After 1987, it includes the original payment schedule through the manner of the retention remains the same as the promise note. Before 1987, include the original repayment schedule. News media and formats requirement providing the media with acceptable acceptable to the Department of Education allows the use of new technology to develop the department and notify schools acceptability media format. Schools should not apply to approval of a media format. There is also additional record retention requirements that apply to the school granted waivers to audit the submission requirements. Record maintenance. Acceptable formats. The school must maintain all records systematically in a useful manner. Unless specific is required, a school may keep its records in a hard copy, microform, copy file, optical disc, CD-ROM disk, or other media formats. Returning the retention of requirements for institutional student information record are discussed in all records, and regardless of to the format, must be retrievable color hard copy. For example, easy understand the printout or computer file or a media format acceptable for the department. Requirements for the electronic promissory note of the Title 34.668.24D31 through 1 through 4. Any document that contains a signature seal for certification, any of the images required to validate the authenticity information maintained with the original hard copy or image media form. This includes tax returns, verification statements, student aid reports used to determine aid eligibility, any other documentation, signature seal, or etc. contained in the necessary documentation to use to the purpose for which it is retained. School may maintain a record of image media for the format only if the format is capable of reproducing accurately legible, completely on copy of the original document with printed in copy must be approximately the same size as the original document. Please note that the promissory notes are signed electronically, must be stored electronically, and the promised notes must be retrievable coherent format, which is because the MPNs are stored on CODs. This requirement can be also satisfied on CODs. School requirements in student aid reports and institutional student information records. The special maintenance of the requirements apply to the student aid report and student information records are used to determine eligibility. If the essential of these basic eligibility required be available, the consistent, comprehensive, verifiable format for the program review audit purposes, hard copies of student aid reports submitted to school must be maintained available for the original format, image media, and as in student information record, any electronic record must be maintained available in an original format as it was achieved in the ED Express software. Supplied to the school. A school that is using the ED Express software, the ability to preserve the information student information record, institutional student information record data that is maintained during the applicable reward chart, archiving the data to the disk and other computer format. Examination records. Location. The school must make its records available for the Department of Education location designated by the Department of Education. The education of this record must be available for the review, including any records transaction between the school financial institution, school deposits, federal student aid funds. School is not required to maintain the records in a specific location. It must be a prompt that the school maintain some poor records of financial aid, maintaining the others business and office office register of responsible administration, office maintain and repair records, and should be aware of the applicable record retention requirements. Cooperative agency representatives. Cooperatives must extend the cooperation must extend to the following individuals authorized and representative: independent auditor, secretary of the Department of Education, Department Inspector General, Comptroller Generals of the United States. See Volume 2, Chapter 2, the Merit Information Audit, Independent Audits, and Program Reviews. School may also provide cooperation with a guarantee agency, whose program the school participates in. School accreditation agencies. Cooperation agency representatives. School participates in federal student aid program. School is third party. It must, if any, must cooperate in any agencies and individuals conduct any audit, program, review, investigation, other review authorized by law. See sidebar. School must cooperate by providing timely access request records pertinent books, documentation, papers, computer programs, examination copies of any agent listed above the record. Timely access provided, including not limited to computerized records, records of reflection, transaction, any financial institution which the school service deposits the deposited federal student aid programs. Responsible access to all personnel associated with the school service administrator of the federal student aid program to which the school agents listed on the obtaining the federal relevant information. A school or services must not allow personnel to submit all relevant information of allowing those personnel interviewed without presence of the school or service management or tape recording interviews of the school or servicers. If requested, the Department of Education school or servicer must provide prominently information to school servicers regarding the last known address, full name, telephone number, enrollment information, employer address of the recipient of the federal student aid program funds who attends or attended the school. The school must also provide this information upon the request of a lender, guarantee, or agency in case of the borrower under the FFEL grant. The FERPA, relevantly law, the Family Educational Rights to the Privacy Act of 1974, does not confuse the FERPA with the Privacy. Do not confuse the FERPA with the Privacy Act of 1974. The government records kept in government agencies include application records of the federal processing of Title 20 U.S. Standard Code 1232G. Researching and developing Family Educational Rights and Privacy Act policy. The Department of the Post Module Notification Family Policy Compliance Office website at www.2ed.gov-policy-gen-guide-fpco-index. FERPA citations, Title 34, 99, 110 through 12, right of the parent and student to review the records, and Title 34 Code of Federal Regulations 922, 22, right of the parent student to request amendments records hearing. FERPA, Family Educational Rights to Privacy Act, sets the limits of the disclosure of personal and definitely information of schools or records, definitions of rights of students to review the records, request the change of the records with exceptions to those noted in Section FERPA and the Family Educational Rights to the Privacy Act. Generally, the post-secondary students' right to the review of the educational records and amend the inaccurate information in those and them provided consistent with the disclosure of the records. These rules apply to all educational records schools keep, including admission records only when the student was admitted, but the academic records was any financial aid record pertaining to the student. Therefore, financial aid office is not usually the office develops in the school FERPA, Family Educational Rights to Privacy Act, or notification to the student's parents all the way that it may have some input. Students' parents' rights to review students and parents' rights to review educational records. The student must provide a student with the opportunity to review his educational records within 5 days of receipt of the request. The school is required to provide the student with a copy of educational records and make arrangements to provide the student with access to his access if federal education. Once again, Federal Education Rights to Privacy Act, responsibles and student rights. Schools are required to annually notify students if the rights of their rights under the FERPA include the notification of procedures exercising the right to inspect, review educational records, maintain record of student files, listing of the personal identifiable information disclosed in legitimate interest. The party obtaining information does not apply to school officials' legitimate education interests or directory information. Student has the right to inspect or review educational records pertaining to the student. Request amendment of his or her records consistent with the disclosure of personally identifiable information. Educational records except for the Family Educational Rights and Privacy Act permits disclosure without consent. Additional Family Educational Rights and Privacy Act disclosure to parents. A school may disclose information from the student educational records to the parents if the case of health or safe emergency that involves the student. A school may let parents of students under the age of 21 know the student has violated a law or policy concerning the possession of alcohol or controlled substance. A school official may share that parents' information based on the official personal knowledge of observation that is not based on information contained in the educational record. Failure to do so would effectively prevent the student from obtaining access to the records. Schools may not charge a fee retrieving the records if it may be chargeable or responsible for providing the copies of the records, provided that the fee would not be prevent the access to the records. While the rights of the Family Educational Rights to Privacy Act transfer the student's parents to from a student's parents to the student when the student attends the post-secondary institution, the Family Educational Rights to Privacy Act does not permit a school to disclose your student education to his or her parent if the student is dependent on student under the IRS rules. Note that the IRS definition of dependent is quite different from the dependent student of the federal student aid purposes. If the IRS purpose student dependent is listed on dependence on the parent's income in the tax return, the student depends on defined IRS disclosure that may be made to either payment, regardless of which of the parent claims that the student is dependent. There are several other situations in which the school may disclose information about the student to the student parents as noted on the sidebar. Sole possession of records. Sole possession of records does not include the term educational record. They are not subject to the Family Educational Rights to Privacy Act. The sole possession of the record is sole possession of the maker of a record and are used as a memory or reference tool, not accessible to be revealed to any other person except for the temporary substitute of the maker of the record. Typically maintained on the school official notice to the individual records to contain the information taken directly from the student and other used and made decision about the student are not sole possession records. Campus security records. Records created and maintained on school campus security of the uniform to law enforcement purposes are accepted. The privacy records exempt from the privacy record restrictions of Family Educational Rights and Privacy Act can be shared with anyone. A school may disclose information on law enforcement unit records to any of the included parents, federal, state, local law enforcement authorities without consent of the eligible student. Prior written disclosure of the student records, except for under the special conditions described in this section, the student must provide written consent with the educational agencies. Schools must disclose personnel identifying information on the student educational records. The written consent is the state of the purpose of the disclosure specify the records that are being disclosed, identify the party class of parties whom disclosure may be made. Be signed and dated if consistent with given electronically. The consistent must identify the authentic of a party identify and authenticate a particular person as a source of electronic consent. Indicate the personal approval information contained in the electronic consent. The Family Educational Rights to Privacy Act regulations include a list of exemptions which are school and the disclosure identified information from the student file without prior written consent. Several of those are also disclosures are there of particular interest to financial aid office since they are likewise to release the financial aid records. Third-party housing records. When the rent is paid to the third party by the school on the behalf of the student, directly on the student, the student housing facility owned by the third party that is a contract with the school to provide housing for the school student under the control of the school. Therefore, the records maintained by either the third party or the school related to the students living in the house subject to the Family Educational Rights and Privacy Act. Purpose citations, Title 34, 930, 30, 99, 31, 99, 32, 99, 33, and 99, 34, and 99, 35. When prior consent is required to disclose information, when prior consent is not required to disclose information, record keeping requirement, limitations on disclosures of other agencies, disclosure of federal state program purposes. Subpoena citations are Title 20 U.S. Standard Code 1232 GB1J1, 2, and B2B, and also is in Title 20 U.S. Standard Code 1232 GB4, and Title 34 Scope Federal Regulations 93, 99, 31, A9, 99, 32. Disclosure of school officials. Some of the other disclosures may be made to officials at the school, at your school, other schools who are legitimate interest in school student records. Typically, they might be admission records, grades, financial aid records. Disclosures that be made. Other school officials include teachers without schools whose school is determined by a legitimate educational interest. To officials of the post-secondary school and school system, the student receives services and seeks to enroll. Um, if your school routinely discloses information to the other schools where the student seeks to enroll, it should include information annual primary notice. Notification of student information is not annual. Notice of the school made pursuant a reasonable attempt to notify the student is in student last known address. Ex partes and orders of terrorism, terrorism crimes, or terrorisms are defined in Title 18 U.S. Standard Code 2331 and 2332 BG5B. Disclosures made by authorized representatives, U.S. Department of Education for audit, evaluation, enforcement purposes. Authorized representative include employees, department, and such employees of the official Office of Federal Student Aid and the Office of Post-Secondary Education, Office of Civil Rights, National Center of Educational Statistics, as well as the firms under the contract of the department to perform the certain administrative functions or studies in addition. The Patriot Act is a Dear Colleague letter issued on April 12, 2002 that changes the Family Educational Rights of the Prohibited Acts by 2001 of the Patriot Act and posted by the PDF edgov.policy.gen.general guide FPCO PDF HT Terrorism PDF. ED Families Policy Compliance Offices with a WW2 ED Gov Policy Generation Guide FPCO Index. Email FER Family Educational Rights and Privacy Act at ED Gov. Disclosures may be made in content with the financial aids received and disclosures of the government agencies. Disclosures may be made if in connection with the financial aid student received and applied. Such a disclosure may only be made if the student information is needed to determine the amount and conditions of student's eligibility, aid, and enforcement of the terms and conditions of aid. The school may release personally identifiable information on the FJM non-immigrated student U.S. Immigration Custom Enforcement, formerly Immigration Naturalization Services, is in compliance with the Student Exchange Visitors Information System program without violation of the Family Educational Rights of the Privacy Act. Disclosure of the responsibility of subpoena and court orders. Family Educational Rights and Privacy Act permits to disclose educational records without student consent to comply with lawfully issued subpoenas and court orders. In most cases, schools must make a responsible effort to notify the student is subject of a subpoena and court order before the complying with the student may seek protective action. However, the school does not have to notify the student if the court is issuing agency has prohibited such disclosure. All schools may disclose information from the educational records without consent and knowledge of the student and to the representatives of the U.S. Department of Justice in response for the ex parte order issued in the connection with the investigation of crimes of terrorism. Documentation of requests not required. A school does not have to have a record incident where the request to the access is made by a parent eligible student at school, that official who a legitimate educational interest is party which is consent with a parental eligible student. Parent or eligible student, a party seeking directory information or certain court orders or subpoenas. Documentation accepted of the note on except as noted on the sidebar, school must keep a record of each of the requests for each of the disclosures of the personal identified student information to the other parties. The required must identify the parties requested for the information of legitimate interest. The record must keep the student's file as long as the educational records are. For instance, if the department official requests a student record in the course of the program review, the school must be documented in each of the student for the study records which is disclosed represented the Department of Education. The easiest way for the school to do this is photocopy a statement of the effective include the student file. A statement filing which would be appropriate to review the federal student aid program conducted by the Department of Regional Aid Regional Office. The financial aid record is disclosed representative of the U.S. Department of Education School Participation Team region of the month and year determined in compliance with the financial aid requirements of Title 34 Code Federal Regulation Part 9931A4. The HIP HIPPA, privacy of health records of the family education requirements. The Health Insurance Portable Accountability Act sets a standard to protect the different confidential health information. However, the Health Insurance Portable Accountable Act excludes the coverage of these records and protected by the Family Educational Rights Privacy Act. The school district of the post-secondary institution provide health and medical service to the student. Because of the Congress specifically addressed how the educational records should be protected by the Family Educational Rights and Privacy Act, the reasons records should be the Family Educational Rights Privacy Act are not subject to the Health Insurance Portable Accountable Act. Privacy rule may be shared with the parents under the circumstances described here. Your school's disability service office normally obtains maintained health records for each of the student who applies the service or waiver, so receipt maintains the health record and student services is well established. Note that in many cases, a student receiving a waiver of the school academic accredited policies applied for services, school disability services offices, schools must financial aid or not handling or medical records. It may be practical to have the Disability Services Office maintain the record references for the record of the file of the financial aid offices. Of course, your school will not have to ensure the record maintenance requirements are complied with. For information about the Health Insurance Privacy Accountability Act of the U.S. Department of Health and Human Resources, contact www.hhs.gov-OCR-HIPAA. The HIPPA regulations are published in Title 45 Code Federal Regulations, Part 160, 162, and 164. When read, disclosures, the anticipated additional parties to whom the information will be disclosed include the record of the original disclosure. For instance, in continuing example, the Federal Student Aid Program, through the following statement might be added. The school eligible channel may further disclosure of the Information Department Office Inspector General to use the Department of Justice under the Title 34 Code of Regulations 99 and 33. Schools should check the program review to find out the redisclosure anticipated. The E-Signature Act. The Electronic Signature of a Global Nation of Commerce Act was enacted on June 30, 2000. The E-Sign Act provides that part of the signature contract, other records relating to the transaction may not be dependent legal act validity enforcement solely because of the electronic form, because of electronic signature, and electronic record using the information. Disclosures via the website, subject to certain conditions. Disclosure may be made on the internet and intranet sites of the Title 34 Code Federal Regulations 66841B and C. Voluntary consent required. Voluntary consent is particularly with electronic transactions required of all financial information provided and made available for the student loan borrowers and all notices authorization federal student aid recipients required of the Title 34 Code for Regulation 668-165 notice and authorization. See Volume 5, Information Notices, Authorization, Disbursement. The E-Sign Act. The E-Sign permits the lender's guarantee agency schools to use electronic signatures, electronic records, and participation with traditional signature records that use under the HEA underlying regulations otherwise provided, maintained in hard copy format. The e-signatures provides specifically creation, retention, of electronic records. Therefore, the statute regulation specifically requires the school to provide and maintain records of document paper. The school provided to maintain all the records electronically simultaneously unless a statute regulates specifically requires the school to obtain pen and paper signature. You may obtain the signature electronically as long as the electronic process complies with the E-Signature Act of all the other applicable laws. Using electronic process notification authorization, so long as no regulations specify that require notification authorization be sent via the USA Mail. School may provide a notice of authorization electronically. It may also have use an electronic process providing the required notice and makes disclosure directing students to secure the website containing the required notification disclosure. For additional information, electronic transaction involving student loans, see Section 2, Standard Electronic Signatures, Electronic Student Loan Transactions, General 0106, 2nd May 2001. Obtaining voluntary consent of the electronic transaction. Before conducting an electronic transaction provided recipient of the federal student aid funds, the recipient must affirmatively consent to use of the electronic record. The recipient of the consent may be voluntary based on the accurate information about the transaction must be completed. The consent must be maintained in a manner responsible to demonstrate an individual access information provided by the electronic format. For example, if your school sends financial information by the email, it could send a request for consent of the recipient of the Viva email required the recipient respond in the like manner, maintaining the record for these responses. Safeguarding confidential information electronic process. Anytime the school uses electronic process to record or transmit confidential information, obtain the student confirmation or obtain a student confirmation, acknowledgement, or approval for the school must adopt reasonable safeguards against possible federal fraud and abuse. Responsible safeguards might include password protection, password changes, set involves access revocation unless for unsuccessful logins, user identification, entry point tracking, random audit services, security tests, and code accesses. The Information Security Requirements of Federal Trade Commission Regulations, Title 16, Code for Regulation 313. 3N, 16, Title 16, Code Federal Regulation 314, 1 through 5, Financial Service Modernization Act of 1999, also known as the Gramm-Leach-Bliley Act of the GLB Act, the Public Law Number 106-102, Sections 501 and 505B2, Title 15 U.S. Standard Code 6801B, 6805B2. If your school electronic process to provide notices of disclosure direct students to secured websites and provide direct notice to each of the year of the student with Viva email, campus mail, traditional mail, or the U.S. Postal Service. Annual individual notice identifying the information required to disclose the year, provided the intranet address where the information can be found. State upon the request, individual is entitled on the paper of the copy. Information students have the request to make a paper copy. Establishing and maintaining the Information Security Program. Federal Trade Commission has rules that the colleges are subject to the provision of Financial Service Act security provisions, also known as Federal Service Modernization Act. Regulation Commission were created, but the definition of financial institution includes the college of the basis of financial relationship that it has with students, donors, and others. Consequently, the college must draft detailed policies for handling financial data covered by all such parents' annual income must take steps to protect the data from falling into the wrong hands. A financial institution, including post-secondary institutions, required to have the Information Security Program under the Federal Trade Commission for the specific requirements of the Federal Trade Commission standard for safeguarding customer information on the following page. Reporting security breaches to the students and Department of Education. Students and schools are strongly encouraged to information on the Students Department of Education for any of the breaches of security of the student records. Information Department considers any of the breaches of student security of the student records information demonstrating the potential lack of administrative capability. On the following page, thus while schools' maximum flexibility is choosing a system provides electronic requests for the release of personal identifiable information, it must ensure the system provide adequate safeguards. Federal Trade Commission safeguard customer information. Post-secondary educational institutions participating in federal student aid programs are subject to the information security requirements established by the Federal Trade Commission by the financial institution. Customers' information must be safeguarded. The requirements also of the customer information school position, regardless of whether the school pertains students and parents or other individuals whom the school or the customer relationship pertains to customers or other financial institution provided such information to you. Customer information means a record containing non-personal information. See the definition of customer financial institution, whether the paper, electronic form, or other form has handled and maintained on behalf of you or your affiliates. Definition of a non-public information is personally identified financial information, any listed description, other grouping customers' publicly available information pertaining to that they derive from the personally identifiable financial information that is not public available. Establishing and maintaining information security of financial institution covered by the use of information requirements. Your school must develop implement, maintain a comprehensive information security program, definition, information security program, administrative, technical, safety guard, use of to access, collect, distribute, process, protect, state use of terminal, dispose, otherwise handle the customer information. Information security program must be written in one of the more readily accessible parts containing administrative, technical, physical safeguard, and appropriate size, complexity of the school, the nature of the scope, and the activity sensitivity of any other customer information issues. The safeguard responsibly designed to achieve the following objectives: ensure security confidential of the customer information, protect against anticipated threat, hazard of security, integrity of such information, protecting against unauthorized access for the use of such information that could result in substantial harm or inconvenience to any of the customers. Okay, and required elements of an information security program. Designated coordinators. You must schedule school. Your school must have a designated employer or employees to coordinate this information security program. Security assessment. Your school must identify the reasonable, foreseeable internal and external risk of security, confidential integrity of the customer information that could result in authorized disclosure, misuse of authorization, destruction, compromise of such information, assess sufficiently any safeguards of the place to control these risks. At the minimum, the school risk should include the consideration risk each relevant to each of the operation, including employee training, management, information system, including network software design, as well as information processing, storage, and transmission and disposal, detecting, preventing, and records responding acts of intrusion on other system failures, safeguarding and testing, monitoring. Your school must design and implement information to control the risk of identifying risk assessment, regularly test, otherwise monitoring effectiveness of the safeguard key control system and procedures. Evaluation adjustment. The school must evaluate adjust the information security program as light of the result of the required testing, monitoring, as well as any of the material changes in operation, business arrangement, any other circumstances that the reason to know how to have a material impact on the information security. Overseeing the service provider is any one of the persons that needs to receive, maintain, and process otherwise permitted by the customer information. Those provisions servicely directly to your your school must take responsible steps to select and retain services provided and capable of maintaining appropriate safeguards customer information at the issue. Your school must require its service providers to contract the implementation, maintaining the safeguard. Source of the Federal Trade Regulations, Title 16, Regulation 313. 39N, Title 16 Code Regulation 314 1 through 5, Graham-Leach-Billy Act, Section 501 through 505, B2, U.S. Standard Code Title 15, U.S. Standard Code 6801B, 6805B2. Chapter 6, Other Administrative Requirements.